Hey everyone, it's Rob Ryder, and we meet again on Thursday, March 27th, 2014, to talk about the courts of inquiry and inquest into insurrection, and also territorial courts that allowing private attorney generals, bounty hunters, and whistleblowers to represent people seeking justice. We're going to be taking back America, one nonprofit at a time. Because the question is, are they really a non-profit corporation? Just because something says it is doesn't make it so. Where's the evidence? Sort of like an affidavit. You get a form says it's an affidavit. Well, is it an affidavit? I don't know. What is an affidavit? Well, by definition, an affidavit is an oath rendered to writing, sworn to before the proper officer. Does that make that form an affidavit, even though it says it is? Nope. It hasn't been completed yet. And so, you may want to be a non-profit corporation, and you may have started the process to be a non-profit corporation, but can you show me the certificate that says you're a non-profit corporation? Similarly, you may say that you're the judge of a circuit court, but can you show me the paperwork that shows that you were elected to be the judge of a court? And even though you show me the paper, is it properly done? Did you start with step one? Are you a registered qualified elector within your election precinct? When that happens. Okay, so some things we'll be covering. And again, this is Rob Ryder. My email address is courtofrecord@aol.com. My phone number. And if you can, please do donate. PayPal is always open, and the PayPal account name is ashleyretluski@gmail.com. Looks like it's an email address. Works as a PayPal account. Or snail mail to myself at 10955 14 Mile Road, Rockford, Michigan 49341. Now, if you put behind that, please don't do it, but my +4 where I live is 493418664. You could do that if you want to. That would just that identifies where I am. 55 at the end of that identifies it right down to the house. However, if it's 49341-0000, well, that appears to be the +4 for the courthouse. And so if that was on a document that no matter what the name was, the address was, or anything else, if it was 49341-0000, especially if it was in the barcode on these machines that read it, that thing's going to go to the courthouse. It ain't coming to you, even if it was to have your name on it. That's my opinion. I think that's just part of the thing of how they can send mail, because they have jurisdiction over the property, and Retluski, Robert Allen is property. It's a name they made up, but it's my property that's underneath that name. And so somehow I've given them a power of attorney to allow them to give it an address other than mine. I think. You know, again, how do you know any of this stuff, right? Till you go find out. But it just these are the things that keep me awake at night. But back to the beginning. So, courts of inquiry and territorial courts. Let's start with a problem, shall we? Let's identify the problem. Let's start there. Okay. Here we go. You got this judge, P. William O'Grady. First of all, who the hell's P? But 15th Circuit Court judge, right? This is supposed to be his oath of office. And, blah, 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 blah. Right? But that's all there is, really. And then they got this sticker on the bottom. And so as we're going to find out, where they see this black line on the side, well, there's a piece of paper sitting over what's on the bottom of this. Yet they're certifying that this is original certified copy of make it bigger. Official certified copy of original document on file. So they're saying this is official, even though it's not quite complete. And then here's some more oaths of offices for other people, like this is for the county treasurer, It doesn't have a seal on it, and we don't have the name of the county clerk underneath there. It says it's the county clerk, but where's the printed name, right? Sign your name. And the same thing with this person. This is for the county clerk now, and this is the deputy clerk. But who the hell's a deputy clerk? I can't read that name. Right. So again, these are not done properly. All right. Well, that was the first go round that Jerry found out down in Branch County. Then we went back again to ask for some more, and here's that P. William O'Grady again. Same one we saw before. And he wanted to get one of the probate judge. Now, as you can see on the probate judge, really this is where the one for the circuit court judge stopped. You see this much. There's nothing else. But it's on the same form as this, as we'll see, and there's more. It does say below here. This is where that piece of paper was, right across here. Sworn to and subscribed before me on this particular day in front of this judge, who's on the other oath that we don't know that he's actually taken an oath, because this sworn to and subscribed part's been covered. Go figure. It says he is circuit court judge. Now, this makes me laugh, right? Anybody who's from Michigan knows what the Great Seal is. The frickin' moose is supposed to be on the right-hand side, and he's supposed to be facing the center of towards the elk. And whatever this furry critter is on the right is looking back over his back. That's not the Great Seal of the state of Michigan. I'm sorry. I don't know where it is, but it ain't the Great Seal of the state of Michigan. Maybe in Oz. In the land of Oz it is. So Jerry wasn't quite done. He wanted to go back and get some more. So he said, hey, blah, blah, blah. And now, here is P. William O'Grady, the one we saw, the first one, 15th Circuit Court Judge. And all of a sudden, the official certified copy of an original document just got longer. Now we can see what's on the bottom. And what does this show? Well, that he subscribed it before some other judge. Maybe. But is the judge a judge? Was he elected? Now, the thing is, now let's pop in on this just a little bit closer. So, where the one asterisk is, it says, this information is requested if oath of office is taken before anyone or someone other than a notary public. Then you got to type the name in. Okay? When filing with the Secretary of State, original signature is required. That's what would go up here, where it says signature. Okay. So by this guy putting his name in here, he's saying that he is not a notary public. I guess if it was a notary public, you wouldn't have to put that in there. Really, I think the reason anybody can accept an oath bond or accept an oath affirmation and so forth is because they were commissioned a notary public. That's the job of a notary public. They may have another job on top, an office, but it's because they're a notary public that they can. And what notaries originally did way back in the early Christian days is they're the ones who wrote down the Acts of the Martyrs. All right, so it's an ecclesiastic office, a notary is. You're working for the Catholic Church. Okay, so as you can see, we got all sorts of things going on. Now these are for and then here's another oath for O'Grady, right? He's got this oath on here, right? This short version, signed by this. Well, it looks like it's a district judge. I guess that's what it says. Now, if you notice, this is State of Michigan uppercase, County of Branch uppercase. I don't know how much of this makes a difference, right? State of Michigan, Branch proper case. Different style of oath. I mean, how many oaths did this guy sign? This man will sign anything you put in front of him if it's going to make him $1. Okay, so their oaths are not correct. Now, what about their bonds? Well, here's a bond for the sheriff. It just so happens they signed, sealed, and dated on March 2014. They just started doing this because Jerry was down there asking questions. But it wasn't signed, right? The sheriff hasn't signed it yet. This isn't a valid bond. It's not dated. It's not signed. Signed, sealed, dated. When? Register of Deeds. The same thing. She hadn't signed hers. It's not dated. And there's our favorite judge, circuit court judge. He hadn't signed his. It's not dated. And even if it was, it just was issued on the 10th of March 2014. This guy's been a judge for many, many years. Why don't these people have a bond? Why weren't these bonds with the treasurer where they're supposed to be? Right? That this was issued by the administrator controller. Treasurer's office didn't know anything about it. Yet again, in the law specifically, it says, hey, that's where this stuff comes from. And then finally, so these are all things we talked about in the prior videos. This is just kind of an recap. When somebody wants to run for office, the very first qualification is that they're a registered qualified elector. And what that means is you have filled out a affidavit of registration within your local precinct, ward, township, whatever the smallest self-governing district of land is that you're part of. You have gone down there and filled out an affidavit that you are a qualified elector registering within this particular jurisdiction, because that's where you live. You're claiming that as your domicile. That's step one. And then you go out and you want to run for office. Then you have to do a nomination petition and get it filled out so you can be put on to be nominated. That's another step. Well, then they have an election, and if you get elected, they fill out. I can't remember the name of the form, but it ends up when it's done that the canvassers look over the election results and they fill out a certificate of determination. And that's what this is supposed to be, a certificate of determination. And the certificate of determination will be signed and sealed by the Board of Canvassers, sent to the Secretary of State and also to the county clerk. And then when that's happened, the county clerk will then issue a certificate of election to whoever was elected. But this certificate of determination was, right, so at this point we've had the election, they've looked at the results and they're saying, oh, these people, see, there's old Bill O'Grady. This is from 2008. Right, here he's Bill O'Grady, he's been William O'Grady, he's been P. William O'Grady. You got a lot, he's wearing lots of hats, and Bill's a naughty boy. And so here's the certificate of determination, and it lists all these people that ran for office, but never is it certified. And then in the same election they asked one question, apparently, Branch County Commission on Aging, millage proposition, and further certifies and determines the following proposition was passed or defeated. Right? So this certification only goes to this thing on the aging millage proposition. Certification. And witness whereof we are hereto set our hands and affix the seal of the Circuit Court of the County of Branch on whatever date it was. And then these names are the signatures of the Board of Canvassers, the clerk, blah blah, but there's no seal on it. Right, so even this wasn't certified, but the main point to me is there is no certification for this document that calls itself a certification. It's sort of like calling it an affidavit but it's not an affidavit unless it's been sworn to before a proper officer. Well, the same with a certificate. Unless it's been sworn to before the proper officer, signed, sealed, delivered, it isn't what it says it is, and therefore nobody has said that these people were actually elected. Further, if you're running for circuit judge in Michigan, that's a state office, and you would be on the state board of canvassers, not the county board of canvassers. And these people didn't do anything. So, okay, the judge, the clerk, the prosecuting attorney, the treasurer, register of deeds, the sheriff, none of them are elected to their office. They have no more authority over you than the guy at the window at McDonald's. What are you going to do about it? Because they do seem to have the guns and so forth against us. Well, we're going to point out the insurrection, because all these offices are offices that are created by the Constitution of the state. So we're going to talk about that in just a second here. I got to load up some other pieces of paper. Hang on a second. Okay, so loaded with the evidence we have that, hey, somebody's broken the state law. They're not holding this office. They didn't follow what it said in the Constitution or the state laws. I say they broke the law. What am I going to do about it? Well, under the Code of Criminal Procedure in Texas, courts of inquiry conducted by district judges. When a judge of any district court of this state, acting in his capacity as a magistrate, has probable cause to believe that an offense has been committed against the laws of the state, he may request that the presiding judge of the administrative judicial district appoint a district judge to commence a court of inquiry to see if a law of the state's been broke. Before requesting the presiding judge to appoint a district judge to commence the court of inquiry, a judge must enter into the minutes of his court a sworn affidavit stating the substantive facts establishing probable cause that a specific offense has been committed against the laws of the state. Okay, well, you have the evidence now. I'm sure you can write up an affidavit and take it in and say, hey, here's my affidavit. I want to make sure, though, that it must be entered into the minutes of his court. You want a copy of the minutes to show it's been entered. After the affidavit has been entered into the minutes of his court, a copy filed with the district clerk. Step 2. The judge shall request the presiding judge of the administrative judicial district in which the affidavit is filed to appoint a judge to commence a court of inquiry. Okay. Well, it seems simple enough. That's how they do it in Texas. And courts of inquiry are under military law. Here's a good book on Manual of Court Martials. Manual of Courts Martial, etc., 1901. Procedure under military law. However, this is what's happened in Texas here recently. Right? A former Williamson County District Attorney, Ken Anderson, was arrested and booked into jail and then released on bail after a specially convened court, which is a court of inquiry, found that he had intentionally hid evidence to secure somebody else's conviction. In a blunt and scathing ruling, District Judge Louis Stern said Anderson acted to defraud the trial court and Morton's defense lawyers. Okay, so let's stop there. Somebody from Williamson County needs to go down and look to find out what was the originating document that got this court to do what they're doing. Where did they take it? How did they get it submitted? Who did they put it in front of? Right? To comply with this very first part here, right? The judge must enter into the minutes of the court a sworn affidavit stating the substantial facts establishing probable cause that a specific offense has been committed. How are you going to get your sworn affidavit in front of them with your evidence? so that they'll convene this court that apparently it will go after a guy that was a prosecutor. In fact, now this prosecutor is a judge. Stearns, presiding over a court of inquiry, found probable cause to believe that Anderson broke 2 state laws and committed criminal contempt of court. Okay, Rusty Hardin acted in the role of prosecutor in the court of inquiry. Don't know who Rusty is, but I have a talk with Rusty. Williamson County celebrated a law and order district attorney for 16 years before he became a district judge in 2002. Stearns' ruling is the first step in a potential case against Anderson, who was Williamson County's celebrated law and order district attorney for 16 years before he became a district judge in 2002. So it sounds to me like Anderson, the guy who's being charged, was a district judge. And they still went after him. Right? If you get your frickin' paperwork correct and bring in the correct evidence before the correct magistrate, they could do the correct thing. So, Missouri revised statutes, military justice, courts of inquiry, duties, how convened, members of court, counsel, approved, blah, 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 blah. Courts of inquiry to investigate any matter, any, A-N-Y, any matter may be convened by the governor or by other persons designated by the governor for that purpose, whether or not that person's involved and have requested such an inquiry. All right, it may be under military justice, but it says any matter convened by the governor or by any person designated by the governor. And in Michigan, that looks like that's a judge of probate. We'll look at that in just a second. But again, says you can do it. Tribunals of inquiry. This is in the UK. They use tribunals of inquiry. Right, for evidence. You're going to bring in the evidence. Here, look at my evidence and see if there's probable cause. If so, go do your thing. Michigan, go to military justice. A court of inquiry to investigate any matter may be convened by a person authorized to convene a general court-martial or by any other person designated by the governor for that purpose, whether or not the person is involved has requested the inquiry. So I don't need to go to the governor. I need to go to the guy that can convene the court of inquiry. And he's appointed whoever can do a court-martial, and that's the adjutant general and the governor, or any other person designated by the governor. Now, who could he have designated? Well, one obvious choice is going to be your county emergency manager, who can call out the military. Jeff in Washington State, when we talked about this some time ago, emergency managers calling out the military, insurrection, blah, blah, blah. He called his emergency manager and asked one simple question: are you the civil authority? And she said, yes, I am. Well, it's a civil authority that can call out the military. Right? So forget the fact that it's in the military code. That's okay with me that it is. We're talking about commissioned officers anyways. Right? So if you're a commissioned officer, you're part of the military. Now, I don't think I have it on here, but in okay, this is Management and Budget Act. Okay, inquiry. The governor may remove or suspend any elective public officer for violation of this act, which constitutes gross neglect of duty, corrupt conduct of office, malfeasance, misfeasance, and malfeasance. Inquiry and administration. Officers having power to administer oaths, affidavits, signatures, title of offenses, prima facie evidence of officer's authority. This had to do with who can give you an oath for this court, if I'm not mistaken. Each staff advocate and legal officer. Doesn't really say who a legal officer is. The following officers shall have the power to administer oaths necessary for performance of their duties. Affidavits may be taken for those purposes before the officers. Each officer is designated to take depositions. Okay, so who can take a deposition? See, what I'm trying to do is figure out who you would take your affidavit to. Right? Do we call the military? Talk to the adjutant general. Do we call the emergency manager? Talk to him. Do we go find an officer who's designated to take depositions, like a court recorder? They take depositions and give it to them. Do we take it to the, as we've done here in Michigan, do we take it to the probate registrar or register? Because when you read their duties, one of their duties is to remove a fiduciary. And we're talking about fiduciary offices and people that have usurped them. Or oaths, affidavits, and depositions in any cause, matter, or proceeding in any court or record may also be taken before any person appointed by the court for the purpose, or before any person upon whom parties agree by stipulation, blah, blah, blah. So if you're, when you read the in witness testimony stuff, they put at the bottom of those certificates, right, that we're talking about, at least here in Michigan, about it being the circuit court of the county, the same being a court of record. Okay, well, who did that court of record appoint as the person I can go before to give an affidavit? All right, because this Section 600, this is out of the Judiciary Act of Michigan. It says oaths, affidavits, and depositions in any cause, matter, or proceeding in any court of record. Right, so first we got to give them a cause, and then it can become a matter and proceeding in the court of record. But what's the cause? Well, we need to give them one. May also be taken before any person appointed by the court for that purpose. So who did the court of record appoint for me to go before to give them my oath and affidavit? I guess that's what I'm talking about. And like I said, court reporters, they do take depositions. Okay. Crime Victim Service Commission, powers and duties, right? If these people aren't holding the office and they've taken your property, well, they committed a crime, and we got a thing called a crime commission. Take or cause be taken affidavits or depositions within or without the state. It's one of their fucking jobs. Excuse my French. All right, so that's the Crime Victims Compensation Board. Administrative Procedures Act. An officer or agency may administer oath affirmation to a witness in a matter before the agency, official acts, and take depositions. All right, so now, removals from office, right? This is right in the statutes of Michigan. Inquiry by attorney general or prosecutor, procedure, compensation, non-residential probate judge, endorsement of witnesses on charges, grand jury testimony. The governor may direct the attorney general or prosecuting attorney of the county for which officer may be, unless the prosecuting attorney is officer of charge, to conduct an inquiry, a court of inquiry into the charges made, right? This is where the governor can direct somebody else. Now, just because a guy's title says he's a prosecuting attorney doesn't mean he's a prosecuting attorney. In Michigan, to be the prosecuting attorney, you're going to have a commission from the governor that says you're the prosecuting attorney. And we've been trying to find that in Branch County, and they, been a lot of confession and avoidance, but I think maybe we just need to go to the Secretary of State and see who she gave it to. All right, so this is just showing, here's an example of the governor directing somebody to be able to conduct a court of inquiry. And it's the attorney general or prosecuting attorney. Right, they're going to conduct it, and then they're going to give 8 days notice to the officer accused and they have an examination of witnesses in relation before some circuit court commissioner, which I don't think we're supposed to have anymore, or judge of probate. It didn't say probate judge, it said judge of probate. There's your court of inquiry. At the time and place specified in the notice, the commissioner or judge of probate for whom inquiry shall be conducted shall proceed to take testimony of the witness produced before him by attorney general and prosecuting attorney, blah, 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 blah. Reasonable and actual fees paid for depositions filed in the clerk's office. Okay, I don't know what that was about, but you get the point. That, you know, they have set it up to have somebody do these courts of inquiry. But one guy that can, because it said that anybody who can do a court martial can do it, well, that's the adjutant general of the Michigan National Guard. And so Bobby in Arizona, he's got a call into the National Guard out in Arizona asking them these questions. So anyways, there was a court case back in the day, Brubaker versus the governor, Supreme Court of Michigan. And the defendant was an elected officer in the county who'd been charged with a felony, and the felony hadn't been processed yet, but they were going ahead to remove him from office. And so the court case had to decide what this was all about. But this is where it says, provides the governor may direct the attorney general, right? This is that law we just read. And so, yeah, the Supreme Court is agreeing to conduct an inquiry, the charge is made, blah, 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 blah. So what the question really came down to, I'm not going to go through this whole thing, but it sounds like to me they weren't really questioning whether this particular judge could hear the case, but whether the attorney general or the prosecuting attorney that we would think of could be the one doing the inquiry. Which is why I think they made a change, and the change I think that they've made is the fact that now this probate register has the power to remove somebody from office, right? To remove a fiduciary. Judicial power of the state is vested in exclusively of one court of justice. Okay, I wanted to find this one thing because it's going to be important later on. The act of removing for cause is primarily administrative, or it's executive. It's not a judicial matter, right? That's what this court case was coming down to. Remove somebody from office is an executive function, not a judicial function. Want to execute the law. The law is already written. This is the thing about John up in Minnesota when he pointed this out, and now he has it before the Supreme Court, that the judge in his case didn't have an oath, right? We don't need him to have another sit-down powwow and discuss it. We need somebody who will execute the law. We're not trying to have it judged. We're trying to have it executed. And they've given this certain powers to the probate court here in Michigan, that the probate judge represents the governor. Well, that means when the probate judge is representing the governor, he is the governor. And he's there to execute the law. But there is something in here. Well, by the judicial power of the courts is generally understood the power to hear and determine controversies between adverse parties and questions in litigation. Right? That judicial power means there's a controversy. And most of the time you're going into court, at least you think you're going to court, which really isn't a court because nobody's been elected. But if it was, that's an in rem hearing. It's a property hearing. There isn't necessarily a controversy. For there to be a controversy, you need to be in personam jurisdiction. So, okay, hang on a second. Okay, I went into Manta, and I just put in Circuit Court, Coldwater, Michigan, which is where this action for all these incorrect oaths, non-bonded, non-elected usurpers of offices are. And, Manta lists different kinds of companies. And so we get the branch county offices. That's for the county. Branch county, friend of the court, branch county district court, probate court. But down here is Branch County Circuit Court. Let's click on that. See what comes up. All right, because what are we going to do, right? They're not holding the office. We're going to go and see if we can get the military to take care of it. But, by what authority do they do what they do? Come on. Sorry, folks. This sometimes happens. Okay, Branch County Circuit Court, 31 Division Street, Coldwater, Michigan, 49036. 0000 is the rest of it. I can have it on there. Okay, Branch County Circuit Court, a privately held company in Coldwater, Michigan. They're not the government. Categorized under courts. Products and services. Companies like Branch County Circuit Court usually offer court services. And so forth and so on. Company contacts. Michael Cherry. Hahn. Michael Cherry, not honorable, just H-O-N. He's not honorable, he's a Hahn. Is the manager. Business information. So, all this to say, okay, they got the SIC code and NAICS code. Now, I don't know exactly what those mean, but someday we're going to figure out what part of that we need to know. My point is that, right, if these guys are a company or a corporation listed, then they're probably listed as a non-profit company or corporation. They're not paying the taxes. And I think that that's been verified by enough patriot mythology that says everything from somebody put something in once, the IRS showed up and hauled a bunch of people out of the courtroom, out of the court building, to the fact that when you start bringing up the tax issues to these people, they get really, really freaked out about it. Okay, so again, just because they say they're a non-profit, are they? There are certain steps they had to go through to become a non-profit. And when it was all said and done, they had to get the piece of paper said they were a non-profit. Right? So do they have that? I don't know. But we're going to see that there's a way to find out, because there is one special court. This is actually the territorial court, as we'll see before we're done. And it's called the United States Tax Court. It costs you $60 to put a petition in. And it's the only court that you can challenge your taxes in before you pay the tax. Well, it looks, when you at first blush, that's all it's for, is just you and the IRS. But yeah, it has to do with you and the IRS for sure. But there's lots of tax issues of which you have a material interest in that aren't necessarily directed towards you, like this court, or the county, or the school board, or any of these other non-profit quasi-governmental agencies that have these CAFR accounts just stuffed full of money, but none of the people holding the office have been properly elected. And chances are they're not really a non-profit. And so if you bring it to the tax court's attention, bring them the evidence, they can do something about it. So let's read a little bit. United States Tax Court. United States Tax Court is a federal trial court of record established by Congress. Oh, so this would be somebody who you can put they have somebody designated you can put your affidavit before. It's under Article 1, Section 8, which says that Congress has the power to constitute tribunals inferior to Supreme Court. Okay. Well, in Article 4, it says that Congress has the power to create tribunals also. Doesn't matter which article it is. It says they had the power to create. It's the same power. All right, but they were established by Congress. Though taxpayers may choose to litigate tax matters in a variety of legal settings outside of bankruptcy, the tax court is the only forum which the taxpayer may do so without having first paid the disputed tax in full. So why would you go fight it anywhere else? Parties who contest the imposition of tax may also bring it to you can go to the United States District Court, the United States Court of Federal Claims. However, these venues require the tax be paid first. It was first called the U.S. Board of Tax Appeals. It was initially established as an independent agency in the executive branch of the government. So it was an executive administrative court at one time. 1929 indicated the Board of Tax Appeals was not a court, instead an executive administrative board, upon the decision of which the parties are given an opportunity to petition for review to the courts. Right? So at first they would give their opinion. You could agree with it or not. If you didn't agree with it, you could petition for a review by the courts. In 42, they named it the Tax Court of the United States. In 56, overcrowding and a desire to separate judicial and executive powers led to the initial attempts to relocate the court. Whatever that had to do with it. But the tax court was again renamed to its current formal designation, changing it from a historically administrative court to a full judicial court. A full judicial court. Interesting. It is an Article 1 legislative court that exercises a portion of the judicial power of the United States, just like a territorial court. The court explained that the tax court exercises judicial power to the exclusion of any other function. That's all it does is have judicial power, right? Judicial power means you're going to, from what it said in the Michigan court, judicial power is the right to determine a controversy. In personam jurisdiction. And it exercises this judicial power in the same way that the federal district courts, lowercase federal district courts, do. The exclusively judicial role distinguishes it from non-Article 3 tribunals that perform multiple functions. The tax court exercises judicial rather than an executive, legislative, or administrative powers. The tax court remains independent of the executive and legislative branches, and its decisions are not subject to appeal review by Congress, or the President for that matter, or Article 3 district courts. Not reviewable by any of those courts. The President, however, may remove the tax court judge, public hearing. They had to have a court case to get them out. And Justice Scalia penned a separate concurrence of 4 justices. The justices dissented with the court's majority rationale, characterized the court's power as executive rather than judicial. Well, they're speaking of what the governor has done with the probate judge in Michigan, where the probate judge represents the governor. That's executive. And he's going to have a judicial hearing. These courts are the courts that are the judge, jury, and executioner. In 2008, categorized tax court under legislative branch. 2012, it's not under a legislative or executive. It's not there. And that's all this list is, executive and legislative. I went to try to find it in this new book, and they don't seem to be in the book at all, but it doesn't have judicial stuff in the book. Jurisdiction. The jurisdiction of the tax court includes, but is not limited to, the authority to hear, right? So here's the things they can hear, but it didn't say it's all I could hear, Well, I'd like a complete list of what it can hear. Tax disputes, yeah, that would make sense. Notices of deficiency, well, a lot of people have gotten those. Certain types of declaratory judgments, that's a loaded statement. There's all sorts of things in there. Readjustment and adjustment of partnership items, that would be with that's all your marriage is. Your marriage is a contract, it's a partnership. It's a union of two estates. Review of failure to abate interest, administrative costs, workers' classification, review of certain collection actions. That would be like liens and levies. All these things can be reviewed or are within the jurisdiction of the tax court. So if you've already had a lien or a levy, it's in their jurisdiction. If they're trying to give you a lien or a levy, it's within their jurisdiction. And let me go find this thing before I go any further, because this would be something we should talk about real quick. Okay, I'm back. So before we go any further, in case you didn't know this is really important. Why you really want to pay attention to this, and we're going to use this court, because there's this manual. It's called the IRS Processing Codes and Information, 2013. It's also known as the IRS 6209 manual, 6209. And in the 6209 manual for 2013, if you go to, I'm guessing here, but it's about page 28. Close. Section 2, Tax Returns and Forms. List of returns and forms. The following list of tax forms showing file source, tax class, master file, tax account codes, blah, blah, blah. Whoa, what was that? Tax class. What this shows is that for every kind of form for the IRS, it goes to a certain tax class between 1 and 5 or 1 and 6. I can't remember what it goes up to. It goes up to 8. It goes up to 8. Tax class. Okay. What's a W-2 tax class? Well, that's tax class 5. I wonder what tax class 5 means. Well, when you go and look, you find out tax class 5 means it's a gift or estate. Gift and estate has a much different exemption than income does. And if Gene Keating's right, and I'm sure he is, it's got like a $5 million a year exemption. So until you make $5 million or get $5 million in gift or estate, there is no tax. Basically, your W-2 is just giving you money out of your account, your own account. It's class 5. W-4s, class 5. But, pretty much everything that you would care about. Okay, because either you're getting a W-2 because you apparently work for somebody else, or you work for yourself and you're going to get a 1099. Or someone's going to give you a 1099. What are those? Look at that. Class 5. Class 5. 1065. 1065. 1096. 1098. 1098. 1099. All of them. So I've heard that people have gotten, they've lost their property in a foreclosure, and then somebody sends them a 1099-C, which is a class 5 gift and estate. And what does it say? Cancellation of debt. What you're supposed to do with this damn piece of paper is you list this number on your tax form where it says gift and estate and put it in. Right, it's a cancellation of debt. Somebody canceled the debt for you. Thank you very much. And so you show it where gift and estate things go, because that's what class 5 is for. Now, we should be using the gift and estate forms maybe and reading those, but nevertheless, 1099s, class 5. Right? It's not income. Quit treating it as income. So you don't owe a tax. Yet they're going to say that you owe something, although they're not going to say this is the unpaid tax. This is the thing. They'll never say this is the unpaid tax. I'm not going to say they never will. That's not what they're going to give you. You may have to get a court order to get them to tell you what the unpaid tax is. But we'll continue on. That's why we're talking about this court. Small tax cases are conducted under Internal Revenue Code, generally involve amounts in controversy of $50,000 or less for any one tax year. Now, $50,000 less what? In tax? Well, if you don't owe a tax, then everything is less than $50,000, so it's all a small tax case. Right? So you can do it at your option. So this is, we're talking about going in and doing a small claims action on a petition that costs $60. And you've got your shit before the court. Important reason of movement. Great single national. The United States Tax Court does not have exclusive jurisdiction over taxes. No, it does not. Here's the other ones that do. The U.S. District Courts, the Court of Federal Claims, and the Bankruptcy Court. The first two, the taxpayer bringing a claim generally must have paid the deficiency determined by the IRS. The deficiency. It didn't say pay the tax. It said pay the deficiency. They're going to send you a piece of paper saying, here's your deficiency. But that isn't what you owe. You're supposed to owe some tax. Where does it say what the unpaid tax is? But if you're going to go to the U.S. District Court or the Court of Federal Claims, you have to have paid the deficiency first. You go to the tax court, you don't have to pay anything first. Thus arises the movement on the part of the U.S. federal tax appeals through merits. There matter much discussion. Blah, 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 blah. The tax court is composed of 19 judges appointed by the President and confirmed by the Senate. Well, the only other people I know they do that with is Supreme Court judges. Former judges, but I guess I don't know that. I shouldn't say that. I know that they do, but maybe they do that with district court judges too. I'm not really sure. It's just that United States District Court is in the 50 organized states, and the territorial courts are in the unorganized, unincorporated federal district. Unincorporated federal district. I don't know that they're unorganized, but unincorporated. Former judges or senior judges, right? They can still work. The court is assisted by a number of special trial judges who are employees of the court, appointed by the chief judge rather than by the president. So they get an appointment. And they serve a function similar to magistrate judges of the district courts, because they are the district court in the territory, and may hear cases regarding alleged deficiencies or overpayments up to $50,000. Now we're talking about the tax. Reappointment, okay. Yeah. All of the judges have expertise in tax law and are tasked to apply that expertise in a manner to ensure that taxpayers are assessed only what they owe and no more. You pay the tax, you don't pay the deficiency. Although the principal office in the District of Columbia, tax court may sit at any place within the United States, and that is why when you look at the anatomy of a township, it says that the township can occasionally, rarely be a district court or can hold a district court. We're talking about the U.S. District Court, although this isn't. It uses the name. They let them do it. It has the same function as an Article 4 court, even though it's an Article 1 court. The tax court permits persons who are not attorneys at law to be admitted to practice to represent taxpayers by applying for admission and passing an examination administered by the court. You want to be a private attorney general, you do it in the tax court. All you got to do is pass a test. And we'll look at some stuff here. The test looks like it's about 16 or 17 pages long, and for 50 cents a page, you can get the questions from the last three different tests they gave. You'll know what kind of questions they're going to ask. The IRS formally determines the amount of deficiency and issues formal notice called a statutory notice of deficiency, or the infamous 90-day letter. So apparently this is after, this has happened, right? Got paperwork going back and forth. They're going to issue this statutory notice of deficiency. Most of the patriots out there are going to tell you, you send that paperwork back, right? Don't look at it. Don't open it. It's not you. Send it back. Yeah, how's that working? In this context, the term deficiency is a legal term of art. It's a term of art, man. It's a legal term of art. It's, colorful wording and is not necessarily equal to the amount of the unpaid tax, which is what you owe. You owe the unpaid tax, you don't owe the deficiency. The deficiency is generally the excess of the amount the IRS contends is the correct tax over the amount the taxpayer should show, or over the amount the taxpayer showed in the return. In both cases, without regard to how much has actually been paid. I don't really know what the hell that's saying, other than I can tell that by wording, unpaid tax isn't the same as deficiency, so somebody swear to the unpaid tax. However, they're going to issue this statutory notice of deficiency. And you got 90 days to file a petition with the tax court for redetermination of the deficiency. That's all you would have to do. $60, send it in, got 90 days to file. If no petition is timely filed, the IRS then statutorily assesses the tax. To assess the tax in this sense means to administratively formally record the tax in the books of the United States Department of Treasury. This formal statutory assessment is a critical act, and as the statutory lien that later arises is effectively retroactive to the date of the assessment, blah, 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 blah. So, if you want to know how much the tax is that you owed, it was formally recorded into the United States Department of Treasury book how much the tax is. Formally record the tax on the books. Well, ask the Treasury, what did they put down in the book for the tax? Well, how do you do that? Well, as it turns out, you do everything with a FOIA request. Because if they don't answer your FOIA request, you can go, it's a court matter, and you can take it to this court. So it's well advised to file a tax court petition in a timely manner. Right? Don't wait till they take your money. You could do it just as soon as you get that 90-day letter. Boom, you file a petition with the tax court. And everything's going to stop until it's done. The rule in the tax court is the taxpayer sues the Commissioner of the Internal Revenue, with the taxpayer as the petitioner and the Commissioner as the respondent. That's just wonderful. This rule is an example of an exception to the general rule that the proper party defendant in a U.S. tax case filed by a taxpayer against the government is the United States of America. We're not going after the United States of America. We're going after the Commissioner of the Internal Revenue Service, of the Internal Revenue, because somebody from his office has issued this frickin' deficiency without telling you what the tax is. I got a problem with the United States of America. I got a problem with his workers. The Secretary of Treasury, Department of Treasury, and the Internal Revenue Service are not proper parties. Don't use them. They got nothing to do with it. The only person that has anything to do with it is the Commissioner of Internal Revenue. He is the respondent to your petition. A $60 filing fee must be paid when the petition is filed. But there you go. Okay. Well, that's cool. Now, how does that make it a territorial court? Well, okay, that was the federal tax court. United States territorial courts. United States territorial courts are tribunals established in the territories of the United States. Most United States territorial courts are defunct because territory under their jurisdiction have become states or been retroceded. They are not United States district courts, though they may sometimes use that term. We're going to call ourselves it even though we're not. United States lowercase district court. Well, that's really the court that we're looking for. And even though they're not, they're using the term because they have the same power as the district court. And it's the United States territory courts. The territorial courts themselves, or Article 4 courts. Well, there's a difference then, right? The territorial courts aren't Article 4 courts. They're territorial courts. Or Article 4 courts is the other type of court. Also assume the jurisdiction of the United States Bankruptcy Court. They do not have separate bankruptcy court under their supervision. They don't have any authority to decide petitioners' appeals to be appointed to or to be appointed to the United States Court of Appeals. in this court case, though they could be considered territorial courts in a semantic sense, since their jurisdiction is not a state, the United States District Court of District of Columbia, Court of Appeals for the District of Columbia Circuit, United States District Court for the District Court of Puerto Rico are not U.S. territorial courts, since D.C. and Puerto Rico are Article III judicial districts. So they could be considered in a semantic sense, although they're not. In addition, the District of Columbia has two other local courts: Superior Court, District of Columbia, District blah blah, which hear cases involving D.C. law only, local law only. Though their jurisdiction is similar to state courts, like other federal courts, they were created by the Congress, and their final appeal court is the Supreme Court of the United States. Okay, so there's something about the Superior Court of the District of Columbia and District of Columbia Court of Appeals. Like the D.C. federal courts, they are territorial courts in a semantic sense, but are not truly U.S. territorial courts. However, these courts are not Article III courts, as the judges serve only 15-year terms, and that's what the tax court judges serve. They serve a 15-year term. The American legal system includes state courts and federal courts. Puerto Rico and Northern Mariana Islands have their own courts, which hear cases involving Commonwealth law. And that's really what we're talking about, Commonwealth law. Though they could be called territorial courts by some, since a U.S. Commonwealth is a type of territory, they are not U.S. territorial courts, as they were created by the Commonwealths themselves and not by the Congress. Right? And the courts we're talking about have been created by the Congress, which makes them a territorial court. The United States District Court in Puerto Rico is not a true United States court, established under Article III of the Constitution to administer judicial power therein convened. It is created by virtue of the sovereign congressional facility granted under Article 4, Section 3 of the Constitution. So this is an Article 4 court. And we're talking territorial courts, which aren't Article 4 courts. Of making needful rules and offering opportunity for non-residents of resorting to a tribunal not subject to local influence. Now, this is interesting. Upon like considerations, Article 3 has been viewed as inapplicable to courts created in unincorporated territories outside the mainland, and to the consular courts established by concessions from foreign countries, to the consular courts established by concessions from foreign countries. So what's a consular court? A tribunal convened by public officials who reside in a foreign country to protect the interests of their country for the settlement of civil cases based upon situations that have happened in a foreign country, and which is held pursuant to authority granted by treaty. Now, I have heard people say before that the courts that we go into are being taped, and that tape is going back to the City of London, and it's all controlled through the City of London. Are those the consular courts are talking about? What we think of as a circuit court or a district court, or we keep saying it's a state court and the state's committing crimes, but they're really not, that they're actually these tribunals from England granted by treaty. The consular court exercises criminal jurisdiction in some instances, but its determinations are reviewable by the courts of the home government. The last U.S. consular courts in Morocco was abolished in 1956. Yeah, well, this isn't Morocco. Are reviewable by the courts of the home government. So it looks like your Court of Appeal is over in the UK, if this is the way it's set up. Oh. Okay, Lyndon Johnson took the Article 4 courts and made them into Article 3 courts. Only occasion in United States history in which the Congress established an Article 3 court in a territory other than the District of Columbia. reason given in this law, federal district courts in Puerto Rico is in its jurisdiction, powers, and responsibility the same as the U.S. district courts in the several states. Okay, there is at least one judicial district in each state. Now, in Michigan, if you go to the FBI's website, it says the FBI for the District of Detroit. And you look at the map they're showing, and it's a map of the whole state of Michigan. One judicial district. The District of Detroit covers the whole state of Michigan. And so, in Detroit is a tax court. Territorial. Throughout the history of federal government, Congress has established courts for the territories of the United States. Generally, these courts have exercised a combination of federal and local jurisdiction. Okay, now we're talking not necessarily Article 4, but territorial courts, of which I believe the IRS or the tax court is a territorial court because the judges serve for 15 years. Generally, these courts have exercised federal and local jurisdictions. Congress typically established such territory a superior court with 3 judges appointed by the president. And so when Michigan first became a territory, the day after the Great Fire of Detroit, where all of Detroit burned down, all of a sudden in comes riding into town the territorial governor and 3 judges. And what had just happened? All the deeds to the city of Detroit had just been burned up in this fire. The whole city was burned. No problem. The government's here to help. We'll take care of it. And that's what they did. Okay. And then the Superior Court judges served during good behavior, fixed for 4 years. The judges served with the governor to enact laws. So the judges went out to different parts of the state, and they would get together and form a Supreme Court a couple times a year, or they would get together with the governor and they would form the legislature. Right? So they had the executive power and the judicial power and the legislative power. They were the judge, jury, and executioner. Congress in 1805 extended to the Superior Courts the authority to exercise the jurisdiction of federal, lowercase district, and circuit courts in all cases in which federal government was concerned. Well, we're talking everything to do with taxes, so they are concerned. The act organizing territorial government of Wisconsin established a new model for territorial courts. And then Iowa got in the picture. And district courts were granted the same jurisdiction as U.S. district and circuit courts in cases involving the federal government. District courts, this is in Iowa, right? If you're in Iowa, you got district courts. They were granted the same jurisdiction as U.S. district and circuit courts in cases involving the federal government. The Supreme and District Courts of the territories possess chancery, which is justice, and common law jurisdiction. Chancery is equity, equity is justice. The Supreme and District Courts, this is the territorial courts, possess chancery and common law jurisdiction. The District Courts of Guam, Northern Mariana Islands, Virgin Islands exercise the same jurisdiction as U.S. District Courts as well as local jurisdiction. Okay, so I don't know. Just seems like it's the tax court. Let's see what else they'll tell us. Some rules from the tax court. So, notice of deficiency of transferee of fiduciary, liability required. Accepting actions for declaratory judgment, for disclosure, for readjustment or adjustment of partnership, administrative cost, review, blah, 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 lien levy, right? These are all things other than what it first talked about getting this piece of paper saying you hadn't paid your 90-day letter, right? These are all things other than that. Got whistleblower awards. Well, how could you be a whistleblower? Well, How can you be an attorney general? Well, let's say, forgetting how, why? If these organizations are supposed to be, you can only be one or the other. Either you're a for-profit or not-for-profit company. Okay? So to be not-for-profit, you had to fill out paperwork with the IRS and get their blessing. Well, did they get the blessing of the IRS to be not-for-profit? If they didn't, well then they're breaking the law because they're not paying their taxes. It's really that simple. How are you going to find this out? Well, you're going to find out by sending a FOIA request to the IRS and asking them if this particular company at this address, the principal's address, what their status is. They got different words they use, and that'll be in another video. I'm just going through the big picture stuff right now, but yeah, and if they won't send you this information, then you can sue the commissioner of the Internal Revenue through the tax court to get a court order to have them release it to you. And somewhere in here I read that 90% of these cases, once you put the petition in, 90% of the cases don't go to trial. They're going to come to the table and settle ahead of time. So you can do a declaratory judgment and for disclosure, and this is what I'm talking about, disclosure. We're going to have them disclose by what authority does that court call itself a non-profit corporation, or whatever we find out the proper term is, and because of that, what tax forms they're supposed to be submitting to the IRS, and by doing a FOIA, are they doing it? Now you can do the same thing with your paperwork you want to get from the tax court. Notice an opportunity for hearing upon filing of notice of lien, right? If you got a notice of lien, you have an opportunity for a hearing. And you can have this hearing through the tax court. And ask them, what's the unpaid tax? Because they're supposed to tell you what the unpaid tax is. I don't know if I can read that in here or not, but and we're going to look at those papers on another video. But what else we got? So disclosure, right? We saw that one of the things you get is disclosure. So this is disclosure of tax return information by Terrell Berkowski and David Flavin. Interesting. Exempt organization personnel should be aware of the information that may be available to taxpayers. Having an understanding of what might be available to taxpayers can be useful in processing cases. Hint, hint, hint. The Freedom of Information Act generally provides that any person has a right, enforceable in court, U.S. tax court, to access federal agency records. Protected from disclosure by one of 9 exemptions, right? Except for these, by special laws, blah, blah, blah. Internal Revenue Code govern public disclosure of exempt organization information. So while this is mainly talking about tax returns or tax stuff, this applies to any kind of record, anywhere you want to get. So the Internal Revenue Code's got 3 different sections that cover these exemptions. But wait, there's more. As you read them, you'll find that there's all sorts of loopholes in the exemptions. So 6103 defines the term tax return and return information very broadly to include just about everything concerning with individual organizations reporting and paying of federal taxes. However, tax returns and tax information may be disclosed under limited circumstances. The most commonly encountered authorized disclosure in exempt organization areas are, right, it tells you where to go look. If you want to know how you can get the shit disclosed to you, go read IRC 6103, Section C through Section O. And one of them you're going to find is persons having material interest in the tax matter may be provided with related tax information. Well, I've got a material interest. I swear to it. Right? Who's going to say I don't? Officers and employees of federal agencies may receive tax returns to enforce federal criminal statutes if requested is ordered by a federal district court judge. Well, we're going to get a court order from a judge to have them give us the information if we need to do that. I don't think it's going to be that hard. I think the IRS is just waiting for us to come and ask the right question and give us the right paperwork. And then you can take it to this court and sue that frickin'. You can be the bounty hunter. You can get the whistleblower reward by pointing out, hey, this company over here that everybody thinks is tax exempt is not tax exempt, and they haven't paid their taxes. And the IRS will swarm in on them like a bees to honey, and go collect their tax. Okay, they got a thing called the Exempt Organizations Handbook. Provides further discussion, provision for laws governing confidentiality of tax information. Right? They're going to tell you what they're telling. So what they're telling you in here is what to go look at to find the information you need to say they're not following the tax law. For public inspection approved applications, recognition of exemptions, right? Form 1023 and 1024 and supporting documents provides for public inspection of approved applications. So was their application approved for them to have the exemption? Inspection of exemption organizations information returns. They're supposed to fill out the form 990, 990EZ. Right? So all these are things that you can look at. So you can put a FOIA request into the Internal Revenue Service to ask for these forms for a particular company. Or you can ask this particular company, how are they, what's their status? Are they exempt or non-exempt? These disclosure requirements apply only to organizations determined to be exempt from taxes. Or from tax. Applications under consideration which have been denied are not subject to disclosure under this law. These disclosure requirements also apply to rulings, determination letters, blah, 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 blah. When an organization's exemption has been revoked, the application is no longer subject to public inspection unless the organization continues to be recognized as exempt for some period of time. So if you ask for this and they don't send it back to you, you know that the company's not exempt. Form 4720 code is disclosable unless filed by disqualified persons as defined in right. So they can show them to you as long as the people aren't disqualified or revoked or whatever. Otherwise, they're not going to have them. However, that's when you can get them by court order. The service is required to disclose the information upon proper application. Private foundations are required to disclose their annual returns. Includes denials, failures to establish revocations. Okay, provides for notifying appropriate state officials of certain determinations made by the service under 501c3, including denials, failures to establish, and revocations. It also describes state officials who are entitled to notification and to inspection of various returns of other documents. So IRS 6104C, if you go read it, it's going to tell you who in the state would get notified of a denial, failure to establish, or revocation. Provides all organizations described in IRC 501c and exempt from taxation are not private foundations to make copies of annual reports. Blah, 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 blah. All sorts of things in here. I'm not going to read it all. I'll send it out, and I'm going to do a video just on this because I haven't gone to all these different sections to see what they say. Just that the mere fact that you can tell by the way it's written, they're telling you all the different places to go look for information to see if a particular organization, such as a school district, court, sheriff's department, whatever it is. If they're listed on Manta as a corporation and it says it's a private corporation, well, let's go find out why it says that. I'm not saying Manta is the best information in the world. It's free. If somebody has one of the paid ones and can get down into the details, or better yet, I know there's a lot of people who understand the IRS stuff very, very well. What are the pieces of paper we need to see that are being hid from us that would be the evidence that they're committing a crime, whoever they are? And you go to the IRS and you ask for that piece of paper. And then you take that frickin' company's ass to tax court. Or, better yet, I don't know if you do that. I still think it's going to be against the Commissioner of the Internal Revenue Service saying, why aren't you collecting the taxes from this company? They don't have a exemption. They just took my check. Right? Either it's for profit or it's not. That's all there is. If you're taking my check, it's either a gift or donation, or we had a business transaction. And I didn't mean in any way for it to be a gift or donation to you. It's a unilateral contract, gift or donation. They're not signing anything and giving it back to you. They may give you a receipt, but you can get a receipt for tax purposes. I think the thing we're not getting is an invoice. Provides for disclosure of the reasoning and legal discussion in private letter rulings to the public. All right, you get the right stuff, man. You get right down to their little pieces of paper they're writing back and forth to each other. How they're going to screw you, right? They're going to self-confess to the crime. It's already been done. Paperwork's in. We just need to get a copy. Under the structure of the FOIA, virtually every record possessed by a federal agency must be made available to the public in one form or another, unless it's specifically exempted from disclosure or specifically excluded from the Act's coverage. The 9 exemptions ordinarily provide only for basis of non-disclosure and are discretionary, not mandatory. So even though there are exemptions, they're not mandatory to be enforced. The government is not required to invoke any exemption to deny access. Right? Now I know that we get stonewalled at some of these different places, but they're not the government. Nobody there is holding office. Dissatisfied record requesters are given remedy in the U.S. District Courts, where the government bears the burden of sustaining its non-disclosure actions. And the U.S. District Court is the territorial court, is the tax court. If there's other ones, I don't know. I'm just saying it looks to me like the tax court is one. And most of these things, everything has to do with the tax one way or the other, right? Either they need to pay a tax or they don't. Let's find out. If they need to pay a tax and they're not, we're going to have them shut down. And then that court isn't there anymore. Good stuff. FOIA specifies only 2 requirements for access requests: that they reasonably describe the records sought, and they may be in accordance with the agency's published procedural regulations. An agency must be careful not to read the request so strictly that the requester is denied information from the agency well knows exists in its files, albeit in a different form from the anticipated by the requester. And this has to do with why they don't want to show you the index. So when you go to the county clerk and you ask for a specific thing, if you don't say it exactly the way they have it, they say, no, we ain't got that. Nope, ain't got it. Well, this is saying you can't do that. Right? You just need to reasonably describe the records. Not placed in agent's records, we're not files, we're not agent's records. Okay. A requester must file a written appeal with the Commissioner of the Internal Revenue within 35 days. So, okay, now we're talking back to, this has to do with FOIA request with them. Well, we know now that if we have a complaint against the Commissioner of the Internal Revenue, you take it to the tax court. They said you make him the respondent. Okay, well, he can respond for them, not providing you the information on a FOIA. If the request for records is denied on appeal, or if the request does not receive a timely response, a complaint may be filed in an appropriate U.S. District Court. Well, again, Commissioner of the Internal Revenue Service, you can sue in the tax court. Right? For disclosure. And this is all about disclosure. For the purpose of exempt organizations, the primary exceptions are, certain things like records such as tax returns, blah, 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 that we're not supposed to see. Records or information compiled for law enforcement purposes, only to the extent that the production of such law enforcement records or information could reasonably be expected to interfere with enforcement proceedings. Well, if someone's ass is already sitting in jail, you can still get the records to find out how they put them in jail. So it says that those are things that, right? Those are things that can be exemptions. But every exemption has a loophole, and the primary limitation on the scope of deliberative process privilege is that it ordinarily is inapplicable to purely factual matters or to factual portions of otherwise deliberative memoranda. We just want the facts. We don't want all the gibberish. Give me the facts. Show me what the tax due was. Show me what you charged them for. And we'll go from there. Yep. So anyways, one last thing, the third traditional privilege. This just goes on and on and on. You can get your own copy. Go back to the top, take a minute, write this down. Disclosure of tax return information by Terrell Burkowski and David Flavin. Right, write it down. Go get a copy. Read it at your leisure. One last thing. What was it I wanted to look at? Then we're done. This has to do with a couple things. First of all, you're going to want to download this Rules of Practice and Procedure, United States Tax Court. I'm going to tell you everything you need to do to you can represent yourself. You can't represent somebody else, right? So if you want to put a court case in, it's going to tell you what to do. I haven't read the whole thing yet myself, but I get around to it. Because what it does say is that you can represent other people. And I'm trying to find this thing because it's just a couple pages long. I'm going to do it this way here. You won't have to listen to me, Jeff. That's what I was looking for. United States Tax Court. Information for applicants who are not attorneys at law regarding admission to practice before the court. A non-attorney may be admitted to practice the court provided the requirements outlined in tax court rules, which is the practice procedure as satisfied by Title 20 of the Tax Court Rules and Practice and Procedure, which was yes. Right here, right? So Section 20 will give you an idea what you need to do. The examination consists of 4 parts. Right? So what you need to do is take a test. You got to be able to pass the test. The court has the questions from the following examinations available for distribution at a charge of 50 cents per page to cover the cost of production. They give this test about every 2 years. In 2014, November of this year, they're going to give the test again. Right, so for $8.50 per year or per test, you can get all the questions that were asked in the test. That ought to give you an idea what it's going to be about. anyways, that's pretty much it, right? That $25 admission fee and $10 periodic registration fee. That's what it costs you to be able to practice, if you want to call it that. You're not going to practice because you're going to be learned in the law. And the largest, there was another thing I was reading on this that said that because there's organizations that give a year-long course in this so you can go pass the test. I don't think it's necessary. I think we should go look at the questions first to determine if we need them to tell us what else we need to know. But they said, oh yeah, the hardest part of the test is the third section, which has to do with rules of evidence. Well, if that's the hardest thing in the test is rules of evidence, how hard can it be? Right? Self-authenticated evidence, an acknowledgement and an affidavit, sworn to under oath. Otherwise, it's hearsay. That's all there is. Swear to it or it didn't happen. That's the rules of evidence. So, anyways, it looks like we have these courts of inquiry. This looks like it's the revenue side, which would be the Court of Exchequer, and we're going to go to the civil side, which would be, hopefully the King's Bench, whoever it is. And if we need to go to the military to get a court of inquiry, well, we're going to see what they have to say. And I'll talk to Bobby here today and see if he's heard anything yet. He had the sergeant scratching his head yesterday, but what was the guy going to do? But I said, I guess I need to talk to legal about this. Yeah, let's get a JAG attorney, and let's tell the JAG attorney. The law says there's supposed to be a general county register of all qualified registered electors in the county. I've gone down there. They don't have the book. They don't have the book. They're breaking the law. Let's go investigate. Because if they're not listed in that book, they can't run for office. So that means the judge isn't a judge, and the governor isn't a governor, and the mayor isn't a mayor, and blah, 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 blah. That there's nobody holding an office. Yeah, it's crazy, isn't it? But that is what it says. So let's go look. The first thing they had to have is an affidavit of registration. Now, JAG officer, you know what an affidavit is, right? You don't just say it at the top. An affidavit is an oath rendered to writing, sworn to before the proper officer. If they don't have one of those on file, they're not a registered elector. Let's go see if we can find some. That's what courts of inquiry do, man. They go and they investigate. So, okay. That's it for me. You all have a great day. See ya.